Hello and welcome to the Voting Rights Institute litigation training here at the American Constitution Society National Convention. My name is Zach Yima, and I'm a Director of Strategic Engagement here at ACS. We have a truly remarkable panel today and a tight time frame, so I don't want to take up too much of your time, but I have to note how truly exciting it is that we have so many people who are here and want to take an active role in protecting the right to vote. Through our partnership with the Campaign Legal Center and Georgetown Law, the VRI has trained attorneys in over a dozen cities across the country and taken part in voting rights cases large and small. In the coming months, we'll be hosting similar trainings in San Francisco, St. Louis, and Boston. For more information about our work, please visit votingrightsinstitute.org. Before I turn over the mic, I have a few housekeeping notes to address. For those taking part in speed networking, the event will be held across the street at K&L Gates, starting promptly at 3:30. The event will run until 4:30, and at 4:30, we'll begin opening the security lines, which we will need to go through before the dinner tonight. The welcome happy hour will be inside the security perimeter. Now I'd like to turn over to Jerry Hebert, the Executive Director and Director of Litigation at the Campaign Legal Center. Jerry has been the driving force behind the VRI, and we at ACS could not ask for a better partner to work with. Jerry?
Thank you, Zach. Thank you. Thank you all. So as Zach said, we have a lot of ground to cover. Just a show of hands, how many people feel they have a good grounding understanding of the Voting Rights Act? Okay, that's good. Okay. We're somewhat going to get in the weeds a little bit today in some cases, but I wanted to first tell you a little bit about what's going to happen. So first of all, I'm going to give kind of an overview about Section 2 of the Voting Rights Act, a little bit on Section 5, preclearance, and then maybe a slide or so on the partisan gerrymandering, which is all of a sudden starting to mushroom up, hopefully, to the Supreme Court, and I'll talk about that in a few minutes. After I get done doing kind of an opening statement, we're going to have Deborah Archer, who is a law professor at New York Law School and a co-counsel with me on a number of voting rights cases, formerly with the NAACP Legal Defense Fund, and a litigator. She and I have a case, and she is arguing in the Fifth Circuit, the city of Hattiesburg, Mississippi. So she's going to talk to you about that case, which is somewhat of a garden variety redistricting case that's percolating in the courts. Then we have Paul Smith, who won a Supreme Court argument this term 8-0 in the Arizona redistricting case, and argued another case involving attorney's fees that he also prevailed 8-0. So he's 16-0, which that puts Paul in the Hall of Fame, in my view. So most of my cases, I lose 5-4. So it's, and then after Paul talks about the Arizona case, maybe the Alabama case, the term before this, the recent decision in Virginia, and the case is percolating up to the court in North Carolina, which we've all been reading about. Justin Levitt was here from the Justice Department, Deputy Assistant Attorney General in the Civil Rights Division, oversees the voting rights section. And we're excited always to hear about DOJ's role in protecting voting rights, particularly this fall, where we do expect a lot of problems. And speaking of this fall, Pam Carlin needs no introduction. She's already in the Voting Rights Hall of Fame, along with a whole bunch of other halls of fame, frankly. Law professor at Stanford, Supreme Court advocate. We could spend the 2 hours talking about her credentials. And in my view, hopefully, a future Supreme Court justice. She is going to give us the overview of the post-Shelby world for litigators, and she's going to tell you what she expects in the fall, and she's going to encourage us to participate. So, without further ado, let me begin. And let me begin by saying thank you for being here. We were going to have tables and chairs, but then there were so many RSVPs that they said, no, we can only do chairs. So we'll try to keep it moving so that we're comfortable here moving on. So I've already hit next slide. All right, so Section 2 of the Voting Rights Act is a long statute. And so what I've done here is bold some of the provisions that you need to pay special attention to. So first of all, when you bring a lawsuit challenging a voting practice, typically if it's a race-based claim or claim on a language minority, you're bringing it under Section 2 of the Voting Rights Act. And the test is not an intent test, it's a results test, amended in 1982. And it's a totality of circumstances test. You have to show that the political processes leading up to the election of people are not equally open to participation by whites and minorities to the same degree. And you show that the members of the minority group have less opportunity than to participate effectively in the political process and to elect candidates of their choice. Now, that usually is a term that comes up when you're challenging methods of election or redistricting cases. Minority groups have a right, if they meet certain conditions, to elect candidates of their choice. I didn't say candidates of their race, I said candidates of their choice. Typically, black voters will support black candidates, Latino voters will vote as a politically cohesive group for Latino candidates, but it's not always the case, and you have the right to elect a candidate of your choice. So, Section 2, therefore, has some key points to it, the totality of circumstances. You look at those in the jurisdiction. Is it equally open to nomination or election? So primary elections count. Whether or not minorities have less opportunity to participate in the political process and elect candidates of their choice. And if you have a lack of minority office holders, let's say the jurisdiction you're suing happens to be 50% minority, and on the city council there are 0 members of the minority group, that lack of minority office holders is definitely a relevant factor, although there is no right to proportional representation. And I'm kind of giving you kind of 30 years of case law here in 2 or 3 slides. And by the way, if you want a copy of these slides, I will make sure that ACS gets them and we post them and you can have them. So don't mad dash feel like you have to write everything down. So Section 2 applies nationwide, which is good, all 50 states. It's a results test. There are 3 jingles preconditions if you're bringing a case challenging a method of election or a redistricting plan. You have to show, first of all, that the plan you're challenging, that you could create an additional district in which minority voters could elect the candidate of their choice. So you have to be able to show that you can create usually one more majority-minority district. And you have to show minorities are politically cohesive, that is, they support the same candidates. And the third jingles factor is you have to show that whites or Anglos vote as a block against the candidates of choice of minorities. So there's that 50% rule in there. You have to show that minority voters in this hypothetical additional district could actually form a functional majority to elect. And again, proportionality is relevant. You may hear terms today of fragmentation and packing. So fragmentation basically happens if you have a minority group that all is geographically concentrated and they draw the line in such a way as to split the minority group so they aren't a commanding majority in a district. That would be an example of fragmentation. Packing minority voters into a district at a level way higher than they need to be to elect their candidate of choice and therefore to prevent the creation perhaps of an adjoining district. That would be an example of packing. And then we're going to talk a little bit perhaps today about voter ID cases, which are really not dilution cases. Those are denial cases where people who are registered to vote already, and I handle the Texas photo ID case, which is now pending in the Fifth Circuit en banc. We, in that case, we have over 600,000 people in Texas who were registered to vote who did not have the photo ID necessary to vote at the polls. So we'll talk about those denial cases for a minute too. So just some general observations. The 3 questions under jingles is to see if a minority opportunity district is required. If the answer to any of those 3 jingles preconditions is no, then Section 2 will not require, those are the 3 I just mentioned, does not require you to create an additional majority-minority district. Now, I've talked about racially polarized voting. This is the definition from the Supreme Court of the United States in jingles. Racially polarized voting, which are those 2 and 3 prongs I mentioned, political cohesion and whites voting as a block, that's where there's a consistent relationship between the race of the voters and the way in which those voters vote. Or to put it differently, where black and white voters vote differently. And there's a statistical test for that, which we won't get into today. But I do tell you that when I try cases under Section 2, I always have to do my opening statement and my arguments to a 6th grade class if it involves math, because that is about the level of a federal judge's understanding of math. It's about 6th grade. So if the 6th graders get it, I can feel I've really got it down to where the goats can get it, so to speak. So we compare the number of majority-minority districts for determining proportionality. It's a strong indication that there's equality. So if black voters are 45% of the jurisdiction and they have half the seats, that's probably an indication there may not be inequality of political opportunity. But lack of proportionality isn't enough to establish Section 2 liability, and proportionality, even if you have it, is not dispositive, and it does not require maximization. So basically, at the end of the day, the overview of Section 2 is that there are really 5 prongs. You have to show that you're sufficiently numerous and can create a compact district in which minorities are in the majority. An additional one, minorities are politically cohesive, whites vote as a bloc, they don't have proportionality, and then you look at the totality of circumstances, which include a whole bunch of factors set out in a Senate report, like socioeconomic disparities, racial appeals in the electorate, all kinds of things that you would imagine apply in the totality of circumstances. Pam is going to talk about Shelby County, but I'm just going to tell you that prior to 2013, a day that will live in infamy, Armin Durfner, who's sitting here, a longtime legendary voting rights lawyer, and I were in the courtroom with Leslie Prohl from LDF when the Chief Justice announced that he had the decision in Shelby County, and my heart sank because I knew what was coming. And he held that the coverage formula for the preclearance provisions of the Voting Rights Act were unconstitutional. Now, until that day, any state or local government in 16 states had to prove in advance of undertaking and implementing the change that the voting change was non-discriminatory in its purpose and effect. And the burden of proof was on the state or local government, and you could only get preclearance from Justin Levitt's Justice Department or in the D.C. federal court. Sorry, Justin, you have to own the Justice Department in its entirety today. I'm sure Loretta Lynch will forgive me. So in this 5-4 decision, Chief Justice Roberts, writing for the court, strikes down the coverage formula, which had triggered which states would be subject to preclearance. And that coverage formula was based on a long history of discrimination in the voting world and the fact that minorities had a decreased level of turnout under that formula. And it was declared unconstitutional as a violation of the Constitution's equality among the states doctrine. And don't laugh when you hear that, because it's usually used to decide what states get back into the United States after the Civil War. And also, what was the other line, Pam? The dignity of the states doctrine?
Yeah, it's the equality and dignity. There were 2 cases where the court talked about that the same way. One of them was United States against Windsor, where they talked about the equality and dignity of people, and the other was Shelby County, where they talked about the equality and dignity of the states.
So, okay, well, there you are.
Me, I prefer the people.
I prefer the people myself, too. So I guess if corporations can be people, anything can happen. So what the coverage formula being declared unconstitutional did, it rendered the preclearance provisions of Section 5 a nullity, because if nobody's covered for preclearance, then even if the provisions are still there, nobody has to submit voting changes for preclearance. The Supreme Court said that Congress had the power to craft a new formula based on current conditions. That's in quotes. And the court said the formula was seriously out of date, and acting in its legislative capacity, said that it did not reflect current conditions anywhere in the country. So it's really nice to have the Supreme Court as a legislative committee of the United States Congress. Section 2, however, the section I went through before, that's left intact for now. So the impact of Shelby County, very quickly, at least in one example, and this is the case, and I'm going to just finish up on this one and then turn it over to Deborah. So Texas enacted a photo ID law in 2011. Now, that was 2 years before Shelby County, and they had to get preclearance of the law because Texas was covered under the preclearance provisions. So they didn't want to go to the Obama Justice Department. Greg Abbott, the Attorney General, felt that that was beneath him, that he was going to go to a federal court in Washington, D.C., where he would get a fairer shake. And he got shook, all right, but I don't think he thought it was fair. So a 3-judge court found in 2012 that the law would have a harmful discriminatory effect, the photo ID law, on minority voters. Now, the case went up on appeal. Texas appeals everything to the Supreme Court. In fact, I think I looked at the docket on the Supreme Court. It was like a third of the cases they heard this term came out of Texas, which speaks volumes about a lot of things. So while the case was on appeal, Shelby County gets decided, basically saying Texas and other states aren't covered anymore. So the decision of the D.C. court is vacated. And the Attorney General of Texas tweets within a few hours of Shelby County being decided, hooray, our photo ID law is now in effect, even though a 3-judge court had just found it to be discriminatory, and they implemented it immediately. So Congressman Mark Vesey, who's an African-American congressman from Fort Worth, called me up and said, and he was one of the interveners in the photo ID case in D.C., he says to me, what can we do? I said, we can sue under Section 2, we can sue under the Constitution if it's intentionally discriminatory. It's also a poll tax, so we can bring all these claims. We did. So we filed literally, I think, 2 days later. Armin Durfner, my co-counsel here, myself, and several other attorneys together representing the plaintiffs, voters in Texas who were harmed by this law. The federal court, after a trial, which lasted nearly 3 weeks, found that the photo ID law was adopted with a discriminatory intent under the Constitution. It found that it violated Section 2 of the Voting Rights Act because it had discriminatory results and was an unconstitutional burden on the right to vote because it imposed burdens, even under the Anderson-Burdick test, if you remember that, where you weigh on the one hand the burden on the right to vote and you look at the state's interest on the other and you weigh that out. It even found that the burden was way heavier than any interest the state could advocate. And it found it was an unconstitutional poll tax because in order to get the ID in Texas, you had to pay for it by getting a birth certificate, which you could not get for free. You had to have a certified copy of your birth certificate. So Texas did what it normally does, which is it appealed, and it immediately sought a stay of the district court's injunction in 2014, and the Fifth Circuit granted it. We immediately went up to the Supreme Court, and we lost on vacating the stay. 3 justices dissented, and you may remember the newspaper article about Ruth Bader Ginsburg staying up till 5 in the morning writing a dissent for her, Justice Kagan, and Justice Sotomayor. So the case then goes up to the Fifth Circuit. A panel on the merits then affirms the decision below that it violates Section 2 of the Voting Rights Act. So that means that 7 out of 7 federal judges have found this law to be discriminatory, and yet it remains in effect. Because we then went back this year to the Fifth Circuit and said, you should vacate the stay that you entered back in 2014, because the only reason you entered that stay is because it was a few weeks before the election, and you said, you know, it was too close and it would cause chaos and confusion. Well, here we are now in the springtime of 2016. The primaries have been held in Texas. We got a big presidential election coming up, the first presidential election to be held since the Voting Rights Act of 1965 without the voting rights protections of Section 5. And Pam will talk a little bit about what that means. And so we went up to the Fifth Circuit. 2 hours after we filed our motion, they said, we're going to carry your motion with the oral argument in the case. Well, that meant that we might not get relief for 2016. So we immediately filed a petition with the Supreme Court of the United States, and the Supreme Court issued an extraordinary order, and it said to the Fifth Circuit, you need to decide this case by July 20th. And if you don't decide it by July 20th, these plaintiffs can come back to the court. That's the nicest invitation I think I've ever had. So how did Texas get an ID? I'm going to quit on two slides here. So this is the Attorney General of Texas, now the Governor of Texas. And what he did was, before the photo ID law went in effect, he spent 5 years going around the state convincing people, in his view, that there was massive voter fraud, okay? Even though there was voter fraud by mail-in ballots, which photo IDs have no impact on, because that's really, you don't need a photo ID to vote by mail, unless you're a first-time voter. And there was no voter impersonation fraud. I mean, think about it. If I go to vote and I claim I'm Paul Smith and he's already voted, well, then I'm in trouble, right? Because I'm trying to say I'm Paul Smith, he's already voted. So then I have to hope that they don't know Paul Smith, because if they do, they know I ain't he. And I have to hope they don't know me, because if they do, then they know I'm not him. and I'm going to commit a felony in front of 6 government official poll watchers. That's why this doesn't happen. Or if it does, it happens maybe once a decade while millions and millions of other people are voting. But he goes around the state, and with a PowerPoint. This is the first slide of his PowerPoint. He says that people commit voter fraud at the polls. You want to see who he thinks it is? He says, first of all, I see dead people voting. They're everywhere. They don't know they're dead. They just keep voting. And then he says, and here are the people who commit fraud at the polls. You see any white people in that photo? No, you don't. Then he says the most incredible thing. He says that mail-in ballot fraud is prevalent too. And you got to watch out for those people because they do certain things. They tamper with the envelopes. You have to check the handwriting to make sure that the handwriting on the mail-in ballot application is the same as the ballot. And then the ultimate killer is he says they use unique postage stamps. Now, the forever stamp, an American flag, that doesn't have any racial overtones, right? No. But what stamp did he put up? A sickle cell anemia slide. And when we showed that to the federal judges in D.C., the same happened from the 3 judges. And I knew I had them at hello at that point. So that's what, we have a lot of talk these days about Mexican judges and all this. This is racist slide right here. Just, in case you're wondering what an example of a racist is, Paul Ryan actually had it right this week when he said, yeah, that's a racist comment. Well, that's a racist slide. Finally, the one point I want to make about partisan gerrymandering, Paul Smith, who's on our panel, argued Veith versus Jubilair back in 06? 03.
No, 06.
And then Lulac v. Perry was in 06. So and we had political gerrymandering cases. So in the Supreme Court of the United States, Paul gets up there and right out of the box, I mean, they're just, how much partisan gerrymandering is too much, right? That's the question the court wanted to define. And of course, there were 4 people on the court, 4 conservatives who said in the decision that came out, it shouldn't even be justiciable. And then 4 progressives, liberals on the court said it should be justiciable, and here are the tests that I would employ to say when it goes too far. And then Justice Kennedy, the man in the middle, says, well, I still think it's justiciable, but I don't like any of those 4 tests that these people came up with, so I'm going to say that it doesn't violate the Constitution in this case, but I'm going to say that it is justiciable. It just hasn't been justiced yet, but we're waiting. And you have to prove intent, and partisan effect. Now, there hasn't really yet emerged, since Veith versus Jubilair was argued in 03, a case that has come along that has really said, okay, because every redistricting plan has partisan intent. I mean, that's the nature of redistricting. But when is the effect enough to cross the line? And the Supreme Court has seemingly, and Paul may allude to this in his decisions in the last term or so, where the Supreme Court is seemingly inviting comments and making dicta comments about how partisan considerations in redistricting can be illegitimate. Well, we agree, and we brought a case in Wisconsin that we just tried. My co-counsel, I think Danielle Lang, you're back there, yeah, with me, tried the case. And we have before a 3-judge court, we expect a decision in July. There's also a partisan gerrymandering case in Maryland. And the Supreme Court took 4 redistricting cases this term alone and has already taken one for next year. So stay tuned on that. So that's your overview. That's the quick thing. Will be some conversations along the way as people are talking, but we've got to get everybody in the 2-hour period. So thank you again for coming. Deborah, it's all yours.
I'm in a difficult position. I didn't want to, it's hard to follow Jerry, but I also don't want to follow anyone who's to my left. So I'll just take where I am. As Jerry mentioned, he and I are working on a Section 2 case, Fairley versus Hattiesburg, Mississippi. And in that one case, I think it really embodies a lot of what voting rights advocates are seeing on the ground since Shelby. But it also is an interesting case because the district court judge in that case ignored everything that Jerry just taught you about Section 2 law and seems to have thrown out long-standing Supreme Court precedent in reaching its determination. So first I want to put in the context of some of the things that we're seeing on the ground in voting rights, and then talk about how they are playing out in this case in Hattiesburg. First, following the 2010 census, jurisdictions began to realize that minorities were increasing, minority political strength was increasing around the country, and rather than embracing that, they reacted by being very ingenious and coming up with schemes and mechanisms to try to stamp down that increasing political power, to make sure that they weren't able to elect their candidate of choice, to make sure that minorities were not able to become majorities on city councils, board of aldermen. And so we've seen things such as packing minorities into as few districts as possible, moving away from single-member districts and at-large districts, and even we have seen canceling the election altogether to make sure that minorities did not have an opportunity to exercise their increasing political strength. We've also seen an increase in discrimination at the local level, which is something that folks predicted would happen. And you hear a lot about the state level changes, the voter ID laws, and those are also very critically important to pay attention to. But the challenge is that on the local level, these changes are equally devastating and are not getting the same attention that folks are getting for the state level changes, and you're not getting the same turnout and support, lawyers coming out to help folks on the local level challenge those changes. And finally, we're seeing something that we all knew, and that is that Section 2 cases are difficult to mount. They're a challenge, and they're certainly no replacement for Section 5, that preclearance requirement. So we've seen all those things come together in Fairley versus Hattiesburg, Mississippi. I want to give you a little background about the case factually, and then talk about some of the legal issues. Until 1985, Hattiesburg, Mississippi used to elect city commissioners through an at-large election system. And due to really severe racial block voting, it ensured that the white preferred candidate was always elected for a city commission, and they diluted the black voting strength. So there was a Section 2 challenge, and in 1984, federal court struck down that at-large system, and it was replaced with a mayor-council form of government for Hattiesburg. And it involved a 5-person city council, and each member of the city council was elected from a single-person ward, and the city council exercised all of the legislative power. And then there was a mayor who was elected at large, and the mayor exercised all of the executive power. And importantly, the mayor could not veto any actions taken by the 5-person city council. Since the adoption of the mayor-council form of government in Hattiesburg in 1985, the city council has had 3 white council members and 2 black council members, the 3 white being elected from majority white wards, and the 2 black being elected from majority black wards. No black candidate has ever been elected from the majority white ward, and no white candidate has ever been elected from the majority, no black candidate from the majority white ward. And it never will change because there is such a severe level of racially polarized voting in Hattiesburg. And also important is consistently the 3 white city council folks have band together to outvote the 2 black city council members on issues that are important to the black community in Hattiesburg. So although the city council representation has maintained and been static since 1985, the population in Hattiesburg changed dramatically. In 1985, whites were the majority, but now it's flipped, and blacks are the majority in Hattiesburg. Between 1980 and 2010, the black population grew by 74%, while the white population declined by 28%. And the 2010 census then confirmed that the black population was the majority in Hattiesburg. And again, rather than embrace that new change in Hattiesburg, the city council responded by locking in white majority rule on the city council before the elections could take place and they would be in the minority. So they did a redistricting plan that maintained 5 city council wards. 3 are still majority white and 2 are majority black population, despite the fact that black folks are majority in Hattiesburg. So the city council could have adopted a plan that included 3 majority black districts and 2 majority white districts, and 3 plans were presented to them that would have achieved that for their consideration. They were rejected. They also could have adopted a plan where there were 2 majority white districts, 2 majority black districts, and 1 district that created an equal opportunity for whites and blacks to compete and elect the candidate of their choice. And they rejected that and instead locked in a system where, although the majority of people who cast a ballot in Hattiesburg are black, the majority of people who will govern and make decisions about Hattiesburg are white. So this case went to trial in Mississippi. The district court found that the plaintiffs failed to establish their Section 2 vote dilution case.
Now, this is an example, by the way, of where the math for the district judge, I should have dropped it down to the 4th grade level instead of because listen to this calculation.
Yes, the math doesn't work so well here. But so the district court conceded, and the defendants conceded, that the plaintiffs had met the Jingles preconditions. So we moved on from that, and then the court went on to analyze the totality of the circumstances. And Jerry mentioned that there are a list of Senate factors, and the court literally tallied the Senate factors and said X number are in favor of the plaintiffs, X number are in favor of the defendants, so the defendants win. And that goes completely against the kind of totality of the circumstances analysis. The court has said you're not to apply the Senate factors rigidly. Some of the Senate factors, in fact, did not apply at all in our case, but still were added up in that tally. And some of them the court has instructed should weigh more heavily than others, and the Supreme Court has instructed should weigh more heavily than the others, and the district court ignored that. And in the end, the district court put everything on proportionality, and it ignored the importance of the possibility of creating that 3rd tie-breaking ward. It ignored some very disproportionate packing of black voters. It ignored the existence of extreme racially polarized voting, and it ignored the continuing impact that discrimination has on black members in Hattiesburg. And this is certainly not the searching inquiry that the court says we're supposed to be engaging in Section 2 cases. So I just want to highlight a few of the errors, bringing in some of the facts. So first, the court said the plan was okay because it provides black voters with political power in rough proportion to their share of the voting age population.
Whoa, wait a minute. Rough proportionality, and I thought you said they were a majority, but they only got 2 out of 5 seats.
Yeah, so they're a majority of the population, but for voting age population, the black population is 47.9%, and the white voting age population was 45.98%. And so the court said, that's close enough. If they get 2 out of 5, that's pretty close to that 47% that they are, even though they're a majority of the general population, and they have a higher percentage of the voting age population. 2 out of 3, you should take what you get and move. As I say to my children, you get what you get and you don't get upset. That's basically what the court said to the people of Hattiesburg, Mississippi. And ultimately, the court treated this rough proportionality as a safe harbor for this discrimination and this vote dilution, and found that that was dispositive. In order to achieve the 3 majority white districts and 2 majority black districts, with black people being a majority of the population, the city council engaged in some serious packing of the black population into the 2 black districts. So for the 2 black districts, they have a black voting age population of 74.77% and 77.56%. And this is much higher than it was in previous plans. For the same 2 districts that had consistently allowed black voters to elect their candidate of choice, the voting age population was 54.69% and 47.83%. So they really put an excessive, unnecessary amount of black folks into these 2 districts in order to make sure that they preserved 3 white districts. The district court also ignored the long history of discrimination in voting and every other aspect of life in Hattiesburg that the black population had faced. Some examples: in Hattiesburg, the income per capita is 164% higher for white people than black people. 42% of black people live below the poverty line compared to 26.9% of white people. Black people have an unemployment rate of 19.6% in Hattiesburg, which is 211% higher than white people. And white people there obtain a college degree or greater at a rate 250% higher than the rate for black people. And this was particularly confusing for me, even in light of those statistics and disparities in socioeconomic factors being one of the things that we're supposed to be considering in Section 2 cases. The court rejected that analysis and said that it was wholly unconnected to local facts. So although these statistics are what is going on in Hattiesburg, the court rejected that analysis and said it was wholly unconnected to what was going on in Hattiesburg, and in the end said that this factor weighed in favor of the defendants and not in favor of the plaintiffs. The court also discounted really extreme racially polarized voting. In many of the city council elections that were analyzed and discussed at trial, 100% of black voters voted for the black candidate, and 100% of white voters voted for the white candidates. It was also similar to the mayoral election, which showed extreme racially polarized voting. They looked at the 2001 mayoral election. Again, 100% of black voters voted for the black candidate, and 100% of white voters voted for the white candidate. And this was consistent except for the mayoral race in 2005. And there, 2% of white voters voted for the black candidate. But still 98% of white voters voted for the white candidate, and 100% of black voters voted for the black candidate. And finally, the district court did something that was really quite odd and relied on the election of a black mayor in Hattiesburg and his influence in Hattiesburg to somehow ameliorate and dismiss the inequity in the city council election. Although there's absolutely no support for being able to say, we got it, we're okay over here. And so the fact that we're violating the law over here shouldn't really matter. So the court thought, you all can elect a black mayor, and that makes everything all right. But as I mentioned to you earlier, the black mayor cannot undo any of the actions of the city council, so it's not clear how the court sees that as ameliorating the vote dilution in the city council plan. As Jerry mentioned, this case is going to be argued in front of the Fifth Circuit in August. It'll be interesting to see how the court treats this and whether or not it reinstates some of the existing law that the district court has seemed to dismiss, ignore, and turn on its head.
Thank you, Deborah. Wonderful presentation.
I want to thank the small but strong contingent of New York Law School folks in the back who cheered for me.
The one thing about the Voting Rights Institute takes on cases like this, and when practitioners, as the person who tried this case in Mississippi as a sole practitioner, came to us and said, I don't have the money to pursue an appeal, but I do think there's a case here. And we looked at it and we agreed with him. And we reached out to New York Law School's Deborah Archer, and she agreed with her students to write the brief and to argue the case. And that's what we do. We take cases and we look at them and we try to find counsel who can actually do them if we can't do them ourselves also. So the case is being argued in late August. Now, there's an 8-justice court, so if we get a bad decision and the Fifth Circuit's not the best place to litigate, well, then you go up on a 4-4 tie, you lose again. So hopefully, if we do lose, they'll take their time writing the opinion, and we'll have 5 people on our side. But speaking of the Supreme Court, Paul Smith is here. Paul has argued numerous cases in the U.S. Supreme Court. He's the head of the Supreme Court practice at Jenner and Block. Argued kind of the major 4 voting rights cases: Veith versus Jubilera, Lulac versus Perry, the Crawford, Indiana photo ID case, Crawford, the Arizona case this term. Paul's a gifted advocate and a good friend as well as colleague. He co-teaches with me at Georgetown Law School. Paul?
Thanks, Jerry. I'm going to talk about recent Supreme Court redistricting cases, and they've taken on some interesting new patterns in the last few years. They are all, what the cases have in common, if they have anything in common, is that they are all cases in which the defendants say, what you're challenging, what you're saying we did wrong that was unconstitutional, we were doing it because the Voting Rights Act made us do it. And so the real issue in a lot of these cases is that a valid defense? And a lot of the time, it is valid if, in fact, your interpretation of the Voting Rights Act is sufficiently sincere and accurate that the Voting Rights Act really did make you do it. Because often it is convenient to invoke the Voting Rights Act as an excuse for redistricting practices which are really being undertaken for partisan reasons, sometimes racial reasons, but more often just partisan reasons to try to cement in place a certain partisan outcome in the redistricting maps. So the first one I'll talk about is the case I argued this year and had the refreshing experience of actually arguing for the sort of Democratic side. I was actually representing the independent commission that drew the map in Arizona, but it was under attack from Tea Party Republican plaintiffs. And the refreshing experience was actually winning a case on that side in the redistricting area. A lot of those cases Jerry mentioned, of course, we lost. But Harris versus Arizona Independent Redistricting Commission was a challenge to the state legislative map in Arizona that was drawn by the commission for this decade, and the basis of the challenge was that there was some difference in population sizes among the districts. There is a principle under basic constitutional law going back to Baker versus Carr, Reynolds versus Sims, that you should not unduly have differentials in population between districts in a district map, because of course that gives some people greater influence, greater power in voting than others. And since the 1960s at least, that's been a constitutional problem. But for state legislative maps, the Supreme Court has given the map drawers a certain amount of leeway. Generally speaking, if you stay within a kind of 10 percentage point range around the perfect population equality, you're okay. And so you can have some districts that are 5% larger than the perfect population, some that are 5% smaller than the perfect population. There is that so-called safe harbor. Whether it's a safe harbor is a question. But in any event, that is generally allowed. And that's what the map in Arizona was like when it was finally drawn by the commission. A commission that has two Republicans, two Democrats, and those four pick a neutral, independent to chair the commission. So it was intended to be nonpartisan. And they drew a map that was fair politically in the sense that it gave the Democrats their proportional share of representation in the legislature, and the Republicans their proportional share, which is quite a bit larger. But the Republicans don't like this commission. They're used to running the place in Arizona, and they're doing everything they can to try to attack everything it does. The first thing they did was the year before there was a case in the Supreme Court challenging the constitutionality of the commission itself, at least as applied to congressional districts. The argument being made that the Constitution doesn't allow states to use commissions to draw their congressional districts because the Constitution refers to the legislature. The court ended up holding 5-4 that the commission, when a state creates a commission that can pass laws, it is a legislature. And the four conservatives were very, very unhappy about that. The day after that decision comes down, with Justice Kennedy joining the four more liberal members of the court at the time, this case gets taken by the Supreme Court. This is a challenge to not the congressional map that was in Arizona, but the same commission drew the legislative map. And the argument here is that the smallest districts, the smallest 10 districts in the map, are the ones that were drawn to provide representation to minorities. And they also happen to be the 10 districts in the map that are almost certainly the most democratic districts in the map. And so the argument was that they drew these districts in such a way as to favor the Democrats by giving them the smaller districts, and that the Republican districts were overpopulated, and therefore people in those districts had less influence than the perfect population equality would provide. And there was a trial about this in Arizona. You got a 3-judge court that presided over a trial, and the majority of judges on that court made findings of fact that, in fact, they had done this. They had drawn these 10 smaller districts and the other districts larger because they had been advised that they needed to find a way to create 10 minority districts that were sufficiently effective, had a sufficient minority population that would turn out to vote, that they could be defended to the Justice Department under Section 5 as 10 effective minority districts, 9 Hispanic districts, 1 Native American district. And they were so advised by lawyers who were expert in Section 5 law. This is when Section 5 was still in effect. There was no Shelby County yet. And so there were findings of fact made that the commission did this not for a political reason, not to help the Democratic Party, but to make sure that for the very first time since 1965, that Arizona might actually draw a redistricting map that didn't get denied pre-clearance by the Justice Department. And in fact, it did get pre-cleared. And the process succeeded, but then they got sued by the Republicans saying, well, but you're helping the Democrats. They win this at trial. It comes up to the Supreme Court. I don't know that the court would have taken the case. I think they might have summarily affirmed it, except that it was the day after they had this other decision about the constitutionality of their congressional districts. And so there was some sort of sense that they were not happy with the commission there at the Supreme Court. Anyway, the case gets taken. I could never figure out exactly what the issue in the case was, because we had findings of fact that said the motive was perfectly legitimate, and in fact they had been advised that the Voting Rights Act required them to draw these 10 districts smaller, to spread out the minority population more efficiently in order there would be 10 districts that would actually perform as minority opportunity districts. And as it turned out, that was actually the controlling factor. There was no way to get around it. We win the case 8-0. It should have been summarily affirmed. But they didn't really make a lot of law in the case, other than sort of saying you can use this 10% safe harbor, this variation in the population sizes of state legislative districts, to try to comply with the Voting Rights Act. What was curious, though, is there was this paragraph at the end which suggests that if there had been partisanship involved, it might have been unconstitutional by itself. And what even some amount of partisanship might make a map unconstitutional. And this is curious because the court has said over and over and over again that some amount of partisan intent by itself doesn't make a map unconstitutional, even when there's some amount of partisan effects. That's what the partisan gerrymandering cases, Veith and Lulac, and even before that, Davis versus Bandham, are all said. And so no one's quite sure what to make of that, whether the court is now more inclined to be more strict about partisan gerrymandering. I guess we'll find out when Jerry's case ends up in the Supreme Court from Wisconsin. But in the end of the day, the map lived, and everybody's still got their legislative districts in Arizona.
Paul, was there an argument in the case that they couldn't rely on Section 5 preclearance to justify their map because Section 5 had subsequently been declared unconstitutional?
Yeah, excellent question. By the time this case gets to the Supreme Court, there is no more Section 5 in effect. And so one of the questions in the case, and this came up in several other cases I'm going to talk about, is what do you do about the fact that at the time they drew the map, they had a perfectly legitimate reason to try to get pre-clearance from the Justice Department, but in fact it turns out after Shelby County, Section 5 wasn't constitutionally in effect in the first place. Can that still be a justification after the fact? And the court has shown no inclination to try to say, no, we're not going to let you justify things based on your actual motive at the time of trying to get pre-clearance under Section 5. And I think the reason for that is that if you said that people who deliberately engaged in race-based redistricting in order to comply with Section 5, if that by itself makes the map unconstitutional after Section 5 is thrown out, then basically all the district maps across much of the southern part of the country would all suddenly be illegal. And so, I mean, that's a very scary prospect. But I don't think the court really wants to get in the business of requiring every state that previously was subject to Section 5 to redo its map in a more race-neutral fashion than they otherwise did.
It would violate the equality of the states doctrine.
They would have even more injury from having been subjected to that regime, but violation of the equality of the states. The other cases I want to talk about are all basically of a piece, and they have to do with a strategy that was undertaken by the Republicans in the southern part of the country in this decade. And there was clearly some kind of memo that went out, and they said what we need to do in drawing our district maps this year is make sure that we can put as many African Americans as we can into the African American districts. And the good thing about that ultimately is if you have a situation as you do in most southern states where white people are majority Republican and black people are almost all Democrats, if you can take all the African Americans and isolate them and segregate them off into districts that are heavily, heavily African American, you're likely to isolate off those few white Democrats who happen to live in their area with them, and the rest of the districts will be 80, 90, 100% Republican. And so this was a strategy that was undertaken, and it ends up, what it does is it has excessive degrees of segregation of African Americans in southern states, largely for a political motive ultimately, but nevertheless using race to achieve that political outcome in using kind of rigid rules that say we're going to always have our districts be over this level, or we're never going to let the percentage go down in these African American districts. And then they try to justify it based on interpretations of the Voting Rights Act, which don't stand up to scrutiny. They basically, this is the devil made me do it. The Voting Rights Act made me do it because I have a reading of the Voting Rights Act, which is at some point quite preposterous. And the first case that had this sequence of events and this scenario was the Alabama case decided by the Supreme Court a term ago. This was the Alabama state legislative districts, and they had adopted a policy in drawing their districts that the African American districts, some of which were 75%, 80, 85% African American, we're not going to allow the percentage of African American in these districts, each of them, ever to go down. So we're just going to freeze that percentage in place no matter how high it is, no matter how much higher it is than it needs to be in order to provide people an opportunity to elect a candidate of choice. And in many of those districts, the population was way, way below what it needed to be. There had been a loss of population, but in order to keep the districts 80%, 75, 80% African American, they had to go out and find more black voters and drag them into these districts, and they did that quite deliberately, basically moving people around almost down to the individual based on their race. Quite remarkable degree of race-based redistricting, all justified by this purported idea that if we let the racial percentages in these districts go down at all, we'll be accused of violating Section 5 of the Voting Rights Act. Section 5, when it was in effect, the basic way you could violate it is if you had something called retrogression. If the power and influence of minority voters retrogressed, was less after you made the changes in your law, in your map, or wherever it is, than it was before. And they said, we're going to be accused of retrogression if we let this 80% district become a 75% district, and some of those African American voters will be in another district. An argument that didn't stand up to scrutiny, as the Supreme Court ultimately recognized, and as the Justice Department told the Supreme Court in the Alabama case, it's not retrogression unless you reduce the number of effective African American opportunity districts in the state. The fact that the percentage may go down from 80 to 70 to 60 doesn't have anything to do with it, when in fact the percentage you need in many of these places, even in a place like Alabama, is probably more like about 45 or 50. And so what you're really doing is you're pretending that you have a legal justification for doing what really is largely a political job in terms of isolating off African Americans and trying to make sure that every other district will be so easily controlled by the Republicans that they never have to fight for it, except maybe in the primary once in a while. And so that was held, the court did not hold it unconstitutional. It remanded for further fact-finding, but it said, certainly the idea that you can adopt this rigid formula of never reducing the percentage of minority population and justify it based on the Voting Rights Act is wrong. It's not a justification, and that kind of rigid quota used in redistricting to try to achieve a rigid preset amount of African American population can be viewed as excessive use of race in redistricting. And this invokes the doctrine called the Shaw v. Reno doctrine, which is the doctrine that says sometimes you need to use race to create minority opportunity districts. That's to not violate Section 2. But sometimes you can try too hard to use race in redistricting, either because the shape is crazy or you're otherwise trying to achieve some rigid formula that doesn't have any independent justification. And if you basically are using race more and it becomes the most important factor in deciding how to draw the districts, that violates the Equal Protection Clause. This is the racial gerrymandering doctrine, the Shaw v. Reno doctrine. It used to be hated by minority civil rights advocates, it was the great friend of the more conservative Republicans in the old days. But now things have somewhat switched because this over-segregation of the southern states is being successfully attacked under the Shaw v. Reno doctrine because they're setting these formulas which don't have any justification under the Voting Rights Act. In other places like North Carolina, they didn't just say we're not going to reduce the population of any of these black districts. Instead, what they said is we're going to have a floor. Every single African American district, no matter what the conditions, no matter how much crossover voting there is from white people, no matter how much, whether there's even racial polarization at all, we're going to make sure every one of these districts is at least 50% African American. Even if it's been 42% African American for 25 years and it's always elected the African American candidate of choice, we're just going to plus up all these districts. In North Carolina, they plussed them all up to 50%. In Virginia, the figure that they picked sort of out of the air was 55%. And so both the congressional map and the legislative map, they said we're going to get all the African American districts up to 55%. In the congressional map, that was all of one congressional district. But and so what you've seen is challenges to these. These plans were justified not so much by Section 5 of the Voting Rights Act, but by Section 2 of the Voting Rights Act. They basically said, well, we know you need to have a certain percentage of African American population in order to have them be an effective opportunity district. We're not going to really sort of, there are ways you can figure out what that number is. It depends on local conditions, how much crossover voting there is, turnout, whether African Americans turn out as much as white people. Sometimes they turn out more than white people. There are ways to come up with the actual figure by studying it, and experts do that routinely. But instead of doing that, they're just going to set a number and say, well, we're doing this because this is kind of the quick and dirty way to make sure we have effective districts, and even if we have some more excessive segregation going on, it's not so bad. And so you've seen these challenges. There's been challenges in both state and federal court in North Carolina pending to both the congressional maps and the legislative maps. Those are sort of wending their way to the Supreme Court. The Virginia challenges in federal court have got to the court first. There was a congressional case that got to the court this year, but didn't end up being decided on the merits. This is the case about the one district that was kept at a higher level than it had to be. Whitman was the name of the case, and it was dismissed. It was decided on standing grounds. The reason being that the map had been held unconstitutional. There was a new map put in place. New congressional districts were drawn. The state of Virginia, now having a Democratic Attorney General, Herring, in place, decided not to appeal. So there was no state appellant in the Supreme Court. However, the intervener Republican members of Congress in the case did appeal, and the question is whether they had standing to continue to litigate the case. The court ends up saying they didn't have standing because none of them could say that they were injured by the new map. Why were they not injured by the new map? Because none of them would say if they went back to the old map, they wouldn't run in the district that they're currently running in. So there was no actual, an element of standing is you have to be redressing something. And if everybody's sort of happy where they are now in the new map and wouldn't go back to the old district if it was restored, then there's no injury to fix. And so the case ends up not deciding any of these weighty questions about is a 55% floor, automatic floor, unconstitutional? How does race, how do you think about racial gerrymandering in this kind of context? But the court has now taken the Bethune, what's the name of the case? Bethune Hill case, which is a legislative case for Virginia, raising much of the same issue. They have the 55% floor. They basically had a rule in drawing these districts. One thing we can't do is violate the 55% floor. It doesn't matter what it does to other traditional redistricting principles. It is the principle among principles we're never going to violate. And it was upheld 2-1 by a 3-judge federal court with a very strong dissent, talking about how once you have a rigid quota like this under the Alabama case, that goes too far. So we will have the Supreme Court weighing in on this issue, interestingly, next year, not this year, and answering a lot of these questions. And the North Carolina cases are still wending their way up. I think I'm not sure if there's any cases outside of North Carolina or Virginia at this point on this kind of stuff. Do you know, Justin?
Some of the Florida cases which Jerry's been litigating sort of involve these issues, but they've largely been resolved. So
Yeah.
I think those are the big two.
Right. So anyway, stay tuned on that.
Thank you, Paul. So this issue about politics and race, the intersection of those motivating people in drawing plans is one that the court has struggled with for quite some time, and maybe this Virginia case that's up there now will maybe give us some more clarity as we approach the 2020 redistricting cycle. Our next speaker is Justin Levitt. Justin Levitt actually is the Deputy Assistant Attorney General in the Civil Rights Division and succeeded in that position Pam Carlin. And I have to say that if I had to pick two people in the United States that I would want to have in those positions, it would be those two people. Extraordinary, talented people who just always have great wisdom about voting rights. Justin, when he was at the Brennan Center, wrote something called the Citizen's Guide to Redistricting, which I have on my shelf and turn to occasionally because it's just such an incredible resource. Then he was a law professor. Now he's on leave from there and serving as Deputy Assistant Attorney General, and I thank him for being here. And I'm curious about his what DOJ is planning this year. There are many of us who are hoping to see a lot of action from the Justice Department and are fearful that without the preclearance provisions, there'll be a lot of changes taking place that would have otherwise been blocked by preclearance. And frankly, people like me and the Voting Rights Institute, we have limited resources. The Justice Department's resources are not unlimited, but they're certainly a lot bigger than mine. And so, Justin, we're anxious to hear from you, and thank you again for being here.
Of course. Thanks very much, Jerry. I'm overjoyed that you actually finished one of those sentences as you did. If I had two people that I would choose to be in that role, I thought you were going to say if I had one person, and then it was going to be Pam. And that's correct. I'm really delighted to be here. I have a long and very happy relationship with American Constitution Society. I was one of the founding board members at my law school many years ago of the ACS chapter there. I've been a faculty advisor since, and so this is another way in which I'm more than happy to be here and talking with you all. As Jerry mentioned, so you've heard an awful lot about particular cases and particular doctrine, and I think perhaps as a palate cleanser, he wanted me to talk a little bit about something different, which is DOJ's role in all of this. What is it that we do that is different or the same or adding to what private plaintiffs do, talking less about the individual cases. As he mentioned, I was a faculty member teaching election law, so I could go on and on and on about the doctrine in the individual cases. None of you want that. So instead, I'm going to talk about what we do as an institution a little bit instead. We are relentlessly focused on our role at the Department of Justice. It is ever present in everything we think about. And means we don't have a responsibility to a party, we don't have a responsibility to a candidate, we don't have a responsibility to funders, we don't have a responsibility to anybody other than the law and the American people, and we take that very, very seriously. In practice, that means a few things. I've boiled them down to 4. Since you're not allowed to have 4, I'll make them 3 with a couple subparts. And I will make them quick because I know you're all waiting for Pam. The first part of our role is that we enforce federal statutes. That is first and foremost what we do. And that means a lot of things. That includes some of the statutes you've already heard a ton about, statutes that are immensely important, like the Voting Rights Act, one of the foundational statutes in this area. But it also means statutes that you probably haven't heard that much about. They're important as well, and that means that we do stuff that nobody else does, really. Sometimes that's because there are statutory provisions with no private cause of action. So sometimes we are the only entity that can enforce the statutes that we have. Sometimes it's because others don't have the resources that they would like. Sometimes it's because others can't locate appropriate plaintiffs to bring a certain type of challenge. Sometimes it's because others have chosen to focus elsewhere. But there's a series of things that we do that are really unique to DOJ, and I think they're also important to point out in and among all of the very important work that you've heard about, because we are deeply involved in those issues as well. So just as an example, we haven't mentioned UOCAVA yet, the Uniformed and Overseas Citizens Absentee Voter Act. I'm getting really good at acronyms. That's our way, that's the federal government's way of protecting those who protect us. It's a way to make sure that service members and their families and citizens overseas are able to get ballots in time to make their voices heard, because their voices are every bit as important as all other eligible Americans. And the logistics are quite a bit more complicated. You can imagine everything from living just over a border to being in a theater of war. We make sure that the ballots get where they're supposed to be. I think, so I know that the statute actually requires that ballots be sent out 45 days in advance of every federal election, a primary, a general, or special election, and runoffs when they happen. I think that the Department of Justice is the only entity actively monitoring every state's transmission of every ballot in every one of those elections, so that all UOCAVA voters can vote, so that they get the ballots they need to make the decisions they want to make in time to have those decisions count. We would still welcome amply welcome stronger protection in that regard. The statute we have is good, but is not as rigorous or as robust as we would prefer. And when that happens, we make recommendations to Congress about how to improve that statute, including some legislation pending at the moment, to help bolster our enforcement capacity in enforcing UOCAVA. I mention it now because it's not something you hear a lot about, and that's part of the DOJ role, is to do stuff that you may not hear a lot about, but that still has an amazing impact on all of the voters who vote in American elections. A second part of what we do is our focus on federal statutes, our relentless focus on federal statutes, means that others bring cases or claims that we don't generally bring or that we're not focused on. There are, for example, thousands of provisions in state law regulating the conduct of elections. Perceptive private litigators look to the state laws in the states where they're litigating to see if those state laws can't, in fact, address whatever issue they're confronting a little more effectively or a little more aggressively or with remedies that are a little more on point. We don't enforce state law. It's not to say it's not important. That's just not part of our role, but it's incredibly important to keep in mind when you're conceiving of the voting rights space. There's a whole world out there that a federal institution doesn't have a hand in necessarily enforcing. Similarly, there are only certain ways in which we confront constitutional questions. The statutes guide us in how we engage constitutional questions when it comes to the right to vote. And most of what you hear about in law school, most of what you read about in the papers, boils down to, was mentioned before, questions about the degree of the burden on the right to vote and the amount of justification for it. Jerry mentioned the Anderson-Burdick test. A lot of the challenges in the election space have to do with these sorts of constitutional questions. The DOJ's primary focus is on the statutes that Congress has given us to enforce. And so that means we are really locked in on enforcing the Civil Rights Acts, which have some protections for voters, enforcing the Voting Rights Act, enforcing the National Voter Registration Act, enforcing the Help America Vote Act, enforcing UOCAVA, which I've already mentioned, enforcing the federal statutes that have to do with disabilities. There's an awful lot there. There's more than enough to keep us busy. But it also means that a lot of the things that you read about in the press may not be in that zone that we're relentlessly focused on. And then there's a third category. When we have overlapping jurisdiction, when private plaintiffs can and sometimes are bringing cases that fall under our statute, so when there's otherwise a violation of one of our statutes, we relentlessly evaluate where we can be most effective. Sometimes that means enforcing the law where nobody else is looking. Sometimes that means engaging where our resources or expertise or our access to data can help meaningfully contribute to a case that others either have brought or will be bringing. Sometimes it means weighing in as an amicus or filing a statement of interest to help make sure that when others are litigating a case, that the courts are applying federal law correctly. And in everything that has been mentioned so far, the cases that Jerry has mentioned, we are also a plaintiff in many of them. The litigation against Texas. We have a lot of litigation in Texas. Cases against North Carolina, other cases around the country, we are litigating along with private plaintiffs. There are another series of cases, Paul mentioned a few of these, where we're not ourselves litigants, but we have filed amicus briefs in various courts, courts of appeal or the Supreme Court, or we filed statements of interest in the district courts, making sure that when the law is interpreted, it's interpreted correctly. Sometimes the plaintiffs get it right. Sometimes the defendants get it right. Sometimes, and this happens shockingly often, not, of course, in any case brought by anybody sitting on this panel, nobody gets it right. And so our job is to try as best we can to help the courts get it right. Because we have both the ability, our unique role gives us both the ability and the responsibility to think long term, to think about how any given case is going to shape the law, not only in delivering justice to the individuals on the ground, but in preserving the opportunity for justice for a whole lot of people elsewhere in the country. We are one of the only entities that has that built straight into our mandate, is to be around forever and enforcing these statutes everywhere. And we take that very, very seriously. So those were 3 points. I got 3.5. And the half is really because it's strange for me to ignore what you've already heard about, what you are going to hear about, so I'm sandwiched in between all of the information you've heard. Jerry talked about it, Pam will talk about it, but I can't talk about DOJ's role, including in this election cycle, but not unique to it, without talking about Shelby County. It is, without question, the biggest change in the election structure since the last presidential election, and it is an enormous change in what we do and how we do it. So Jerry talked to you a little bit about the case. Shelby County decided 3 years ago, and we are all keenly aware of that anniversary. Jurisdictions had the responsibility to pre-clear changes to their election laws with us or with a federal court before they went into effect. Congress renewed that structure in 2006, and when they renewed that structure, the court said they renewed it unconstitutionally when they decided which jurisdictions had responsibilities to pre-clear laws with us and which did not. As Jerry said, that decision was focused on what Congress did in 2006. Congress has the ability to update a formula for deciding which jurisdictions have the responsibility to come to us or to a federal court and which don't. And we urge them to take advantage of that responsibility. There is ample opportunity to repair some of the very, very real damage that Shelby County did, and to do so in a bipartisan fashion, because every other time that the Voting Rights Act has been amended or reauthorized, it's been a bipartisan effort. Until that happens, no jurisdiction, or virtually no jurisdiction, there are 3 very small ones under consent decrees, nobody else has the responsibility to pre-clear election changes before they go into effect with us right at the moment. That's a huge change. We used to know about changes in the election laws and the effect that those changes would have on minority populations before they came into effect, because jurisdictions used to have to tell us. They don't have to tell us anymore. And so now, we depend for our information on others sounding the alarm and letting us know when things are changing in their local jurisdictions. We are a lot of places, but we are not everywhere. And so we have been spreading the word like crazy. It's going to sound familiar and it's going to sound cliche, but we mean it. If you see something, say something. We need that help. When we did know about a discriminatory change under the pre-clearance regime, under the pre-clearance system, in covered areas, we used to be able to stop laws before they went into effect. That too has changed. Now we have to sue afterward. And for those of you who are not steeped in voting rights stuff, that sounds like most of the way that attorneys stop harm all the time, right? The harm happens and then you go into court to stop it. And that is regular and normal and in many other areas of the law acceptable. And voting doesn't work that way. Elections are different and meaningfully different for the following reasons. When a discriminatory election takes place, you can't ever get that back. There's no way to make that whole for the people in the jurisdiction. And what that means is that there's very little remedy other than fixing things for the next time around. Meanwhile, if a discriminatory election happens, the officials who were elected are busy making laws, and there's no way to get that back either. Elections are different. People like to say elections have consequences. Discriminatory elections or elections under discriminatory rules have consequences too. That's a big change that Shelby County created. As Jerry mentioned, the fact that we used to be able to stop discriminatory laws before they went into effect has slowed down our ability to respond and get meaningful relief. So in many of the cases Jerry mentioned and some others beside, we have been fighting and are still, in June of 2016, fighting changes that essentially happened in 2011. Blocked for a time, and then up and running. That's remarkable. 5 years in, we are still fighting to get relief on changes that happened in 2011. That's before I was at the Department of Justice. That's before Pam was at the Department of Justice. It's not before Jerry was at the Department of Justice. He's been around a very long time. But just to give you some perspective, when these changes were put in place, I had hair. That is much, much, much too long to wait for justice. And with that, I'll turn it over to Pam.
Thank you very much. Before we hear from Pam, no discussion of the Department of Justice would be complete without noting that the Solicitor General, Don Verrilli, is leaving, and remarkable advocate in the Supreme Court of the United States. When he was up there arguing whether it was Shelby County or any other voting rights case, the Solicitor General's office under his leadership did remarkably well. And when you have the U.S. Department of Justice as the 10th justice from the Solicitor General's office basically up there commanding arguments as well as they did. So I know that Ian Gershengorn is taking over another tremendous former law partner of Paul's as well, as was Don. Just want to tribute publicly to Don Verrilli as he leaves.
And that's entirely appropriate. Before Jerry transitions to introduce Pam and to lead into Pam, Don Verrilli was, is, and has been a spectacular Solicitor General, but he is also, as many of the folks on the panel know, a truly spectacular lawyer and person, and both of those count for an awful lot, too.
Right, absolutely. And there are two bills pending in Congress to come up with a new coverage formula. They're a little bit different, but Congress, the House and Senate committees won't even hold hearings. They claim there's no discrimination. You probably saw Mitch McConnell said that there's no more discrimination. And there's no more blockage to equal voting rights. I think if he wants to see blockage, he just needs to look in the mirror, and he'll see a big blockage. So Pam Carlin is going to talk with us. Justin alluded to this. You sometimes think that, I don't want to say we save the best for last, but Pam Carlin is extraordinary, entertaining, but also brilliant. And I hope someday that my dear friend Pam Carlin will permit me and appropriately call her Justice Carlin. But until then, Pam, take it away, and I'm going to monitor your slides.
Justin will have his hair back before I get on the Supreme Court. So I don't think we have to worry about this. I think people just want to see the confirmation hearings. I don't think that.
I definitely want to see the confirmation hearings.
Yeah, Nina Perales, who's a great voting rights lawyer, promised that if I ever have confirmation hearings, she will bring a group of what are known as the weeping Tias, these women that you can kind of get to go to your funerals in South Texas, to sit behind me and weep as I'm viciously attacked. So I'm looking forward to that, and having my partner put on her Army uniform so I can say, and the little captain back there is very upset by your being so mean. Well, as my hero and one of the heroes and architects of the 1982 Voting Rights Act amendments, Elaine Jones often says, everything has already been said, but not yet by everybody. And so I want you to come away from our discussion today with some ideas about what you can do, because I'm actually more optimistic than the story that we've been telling up here today, which is, sure, there are problems with voting rights today, obvious problems, some of them new, some of them the return of old problems, but we have made huge progress on voting rights since the 1965 Voting Rights Act, and we shouldn't lose sight of the fact that having the long view is important. Having the short view and the medium-term view is important, but also having the long view is important. So I want to start, if you could put up the first slide, Jerry. This is how voting ought to be. This is my experience last Saturday in Santa Clara County. Since I was coming here for this, I couldn't vote in the California primary on Tuesday. So I went to an early voting center. I waited approximately 4 minutes in line. They did not ask for an ID. They simply asked me to sign the poll book. Then they gave me a ballot printed out by the government, picking the right ballot to give me. That is, you could vote from anywhere in the county, and they would figure out which local propositions needed to be on the ballot you were getting.
Not the candidates, not the right candidates.
Yeah.
The right ballot.
Yeah, no, the right, yeah, yeah. And what's going on in this photo, which I took while I was sitting there waiting for my ballot, is you'll notice there's an African-American poll worker and a white poll worker there. Those are the people who are checking people in. The man who's standing up here is a South Asian poll worker. And he is explaining to a Chinese American voter how she can get her ballot printed out in Chinese. Because they printed her ballot out, she looked at it and she said, I'd like the Chinese ballot instead. They printed another ballot for her. This was easy, it was fast, it was dignified. They were explaining to voters who came in who were what are called declined to state voters in California, that is voters who didn't register with a party, that if they wanted, they could have a ballot given to them with either the Democratic primary or the Libertarian primary on the ballot. This is how voting should be. Next slide. This is how voting often is. This is Maricopa County earlier this spring. These are people standing in line long after the polls have closed trying to vote at an early voting quote-unquote super center, which we might call an inferior center rather than a super center. Now, why did they have this problem in Maricopa County? Well, in part they had this problem because they went from having 400 polling places to having about 60. And how did they do that without anybody saying anything about it? Well, you've already heard that story. It's because of Section 5's demise. It's because Maricopa County, which was covered by Section 5 of the Voting Rights Act, is no longer covered, so they had the bright idea that they could just consolidate everything and save money. And the thing is, Americans get the elections we're willing to pay for. We have devolved election running down to the county level, which is a level of government that's under tremendous financial strain. And they often think they can save money by running elections on the cheap. And you get the kind of elections you pay for, not just in the campaign finance area, if you knew. So Section 5 of the Voting Rights Act, if we could have the next slide up, Jerry. This shows the areas that were covered by Section 5 before the Shelby County decision. And what did Section 5 cover? Next slide, Jerry. These are the things it covered, and you're going to see these things coming back around now because these are not just problems in the previously covered jurisdiction. But Section 5 said before you made a change to registration or a ballot casting requirement, for example, before you required people to provide documentary proof of citizenship, or before you required people to present an ID at a polling place, you had to get federal approval. How many of you have currently valid government-issued photographic IDs? Not with you, I just mean in general. Okay, you are not the people I'm worried about. And one of the staggering things in America is just how many people are not as documented up as you are. It also covered things like changes in the dates and times of elections. So if you wanted to get rid of early voting, or you wanted to get rid of Sunday voting, the so-called souls to the polls, which is very important for a number of minority communities because people like to go to the polls with people they know who can assist them in negotiating a process that can sometimes be complex, who can be there to back them up if they're challenged when they try to vote or the like. Those things also were things that were covered by Section 5. Changes in polling place locations or election technology, like the consolidation of precincts, were covered. And there are going to be a lot of changes in where elections are occurring. One of the things that the President's Bipartisan Commission on Election Administration discovered is, you know the best place to vote? The best place to vote actually used to be schools. Why was this a great place? Because everybody knows where the public schools are in their neighborhoods. All of the schools are ADA compliant. All of the schools have bathrooms. All of the schools are public. So they feel like places you're entitled to be. But after the Newtown shootings, a lot of school districts decided they don't want adults who aren't part of the school on school property or in the schools on a day when school is running. So a lot of places have had to find new polling places, and those new polling places can be places that don't feel as welcoming. I mean, I live in California, and I've always felt welcome to vote. But sometimes I voted in people's garages. Or they have private clubs, or there's voting in a church. And all of those things can make people who don't feel part of that community in quite that way uncomfortable about voting. Well, the Voting Rights Act used to look at those things under Section 5, and it doesn't anymore. Changes in electoral district boundaries, annexations, de-annexations, redistricting, you've heard about those. All of those were monitored under Section 5, and they're not monitored anymore. And changes to the rules for counting ballots. For example, are we going to count provisional ballots? Because one of the things that HAVA, the Help America Vote Act that was passed in the wake of Bush versus Gore, said is that every state has to give you a provisional ballot if you show up at the polling place and you're not on the list. What's shocking but not surprising about that statute is it has no rule in it about whether the ballot has to be counted. Every state decides for itself what its counting rules are. And states can change those rules. For example, the state of North Carolina used to count your ballot if you showed up at any polling place in your county. And this is important for people who are working 3 or 4 jobs to make ends meet, because sometimes they can't get all the way home because they had to stay late at work on the Tuesday of Election Day, but they can get to a polling place right near their job. And North Carolina used to count those ballots, and now it doesn't. Section 5 could have prevented that change, but now Section 5 is unavailable. Now, why do I put up all this stuff that Section 5 used to cover if Section 5 isn't around anymore? It's because the demise of Section 5 doesn't actually mean that these things aren't still going to happen. And even when we had Section 5, these problems occurred not just in the covered jurisdictions, but they occurred all over the country. And these are what are called, with the exception of the redistricting issue down near the bottom of the slide, first-generation problems. These are the kinds of problems we thought we had solved in 1965 and 1966 and 1967. But they have reemerged. And they've reemerged at a time when political polarization could not be higher, and therefore we don't have the ability necessarily to go into the United States Congress and get new laws. We have to use the tools we already have. So what about Section 5 made it so important? Next slide, Jerry. This is Section 5. This is an artist's rendition of Section 5. Section 5 objections are the little thing on the top. But why was Section 5 so important? It was not because of the objections themselves. That was one small piece of Section 5. That is, those were the changes that were blocked either by the Department of Justice or by a district court in the District of Columbia, federal district court. It's the tip of the iceberg. What made Section 5 so important is all that stuff that's underwater. So if I could have the next slide, Jerry. Section 5 deterred jurisdictions from doing stuff in the first place. In North Carolina, for example, they knew they couldn't introduce a bill like the bill they ultimately did while Section 5 was in place, because they knew that bill wouldn't get pre-cleared. So you just deterred some changes altogether. The second critical thing that Section 5 did is something that Justin alluded to, which is it gave everybody notice that a change was being made, and that could allow the community to organize and contact the Department of Justice. It could lead to political pressure on the changes and the like. This information forcing piece of Section 5 was also critical, because when a jurisdiction submitted a change to the Department of Justice or to a federal court, it had to provide a lot of information, and that information was really useful in determining whether a particular change should be allowed to go into effect. And it was also useful in getting information about the jurisdiction more generally that would allow for monitoring of other changes. And finally, Section 5 gave places political cover for doing the right thing. A lot of times, jurisdictions would do, as you've heard both Jerry and Paul talk about today, a kind of the devil made me do it. That is, they knew that they shouldn't change polling places in minority communities. They knew that they shouldn't engage in discriminatory redistricting. And they knew that it was wrong to do that kind of stuff. But they also didn't want to say, I'm a good person, because maybe they were worried that the evil people who voted them in the first place would vote them out. And so they could use Section 5 as an excuse for doing the right thing. And that's not there anymore. So, looking forward, where are we? What to look out for in the election of 2016. We're going to see a lot of stuff this election cycle that is an opportunity for you to participate in protecting the right to vote. So if I can have the next slide. Here are the likely changes. We're going to see some last-minute changes in election rules. Some states are going to change the times that voting occurs. Some states are going to change polling places. Other states are going to have new laws in effect that we haven't seen in a presidential election yet, even if they were in place for 2014. And this matters because the electorate in presidential election years is different than the electorate in non-presidential years. A lot of people only come out to vote in the presidential cycle. And so the voters are likely to be younger, they're likely to be less experienced, they're likely to be less affluent. And all of those things make it more difficult for people to vote in the same way that it makes it more difficult for them to negotiate all of the other kinds of things they do with the government. It's not something unique about voting, it's something unique about dealing with bureaucracies or common to bureaucracies. So we're likely to see voter confusion, people who don't understand whether they can or can't vote. People who don't understand where they can vote and the times of voting. We're likely to see long lines in some places, sometimes deliberately and sometimes accidentally. So notorious example from the last election cycle was Maryland was using smart card voting, and in one polling place in Silver Spring, they just forgot to bring the smart cards. Not so smart. You know. So there are going to be a lot of people who are confused. There is also a risk of voter intimidation, both the intimidation that just comes from being new and confused in the process, but also from the fact that some states have new challenge rules. And in states where the election is likely to be close, people have every incentive to show up at polling places and make it seem difficult. There'll be mailers going out to people telling them, don't vote, it's a felony if you fall into one of these categories. There are going to be people who are going to be told you can't vote because you lack the right form of ID. There is police presence at polling places, which sometimes is reassuring to voters, but sometimes can feel a threat, depending on the jurisdiction or the like. And so you have to worry about that. And then you have to worry about the fact that the average poll worker in America is a volunteer, and also often, I think the average age of poll workers is
Older than
Older
me.
than us.
Older
yeah,
than me.
older even than Jerry. Jerry would be a Ute. These Utes. But these poll workers are going to face new rules in a lot of the states. They are going to face large numbers of voters who are first-time voters. They're going to have a lot of different rules that they have to comply with. Justin alluded to some of these rules about assistance for voters. Voters are entitled to take anyone into their poll booth with them they want, other than a representative of their employer or their union. So a voter is free to take their minister, a friend, a relative, a volunteer into the booth with them if they need help in voting. There is going to be confusion over bilingual ballots in various places. If there's high turnout, there are going to be places where they run out of ballots and then they start trying to give you a ballot in another language just to keep the lines moving. There's going to be provisional ballots, and one of the things we've seen in prior election cycles is areas of the country with large numbers of limited English proficiency voters tend to get higher numbers of provisional ballots given to voters, sometimes because the poll workers are just trying to move people through. And if they can't find your name because the way your culture writes the name is different than the way it's appearing in the poll book, they'll just hand you a provisional ballot and push you through. Mm-hmm. Or they won't try to figure out where your polling place is. They'll give you a provisional ballot and not tell you, if you just go 2 blocks down the street to your actual polling place, you can cast a ballot and have it counted. If you cast a ballot here that I'm about to give you, it's not going to be counted. So all of these things are likely to be problems this time around. And depending on the closeness of elections in various places, they can be not just a problem for the individual voter, but an election dispositive problem. So what can you do? Last slide. The first thing you can all do is make sure you're registered to vote and make sure you vote. I mean, I understand you're more likely to be killed in a car accident driving to the polls than to cast a decisive ballot. But you must assume the risk. Be brave. Look both ways when crossing. You can serve as poll workers. Many jurisdictions are still looking for, and will be looking for until the week before the election, enough poll workers to man all of the polls. You can be poll watchers for one of the election protection organizations or for whichever political party you're connected with. You can do election protection work. Jerry is going to have resources outside, right, that will give you a list of places that are going to do election protection work, manning hotlines for voters who have problems and the like. There are a lot of election day opportunities that will be available if things go wrong, assisting voters who want to go down and validate their provisional ballots, because in a lot of places you have 10 days to validate the ballot. So a voter may very easily be able to do that, but they may need help in doing it. There are a lot of resources available from the VRI. But I also want to encourage you to be thinking longer term about these things, because we didn't get the Voting Rights Act in a day or in a minute. It took time, and it took imagination, and it took really hard work. So what kinds of hard work should we be thinking about going forward? Well, one of the things is we should be thinking about state-level work, because a lot of states have some really good law, and they may have really good constitutional provisions as well that people haven't used. A number of voter ID laws were knocked out in state court based on state right to vote provisions rather than on federal law. So know the law of the state you're in, and work to get better state law if you're in a state that has the opportunity for that. One of the best developments recently that we've seen are attempts by a number of progressive secretaries of state to engage in things like automatic voter registration. So that in California, for example, the Secretary of State is working on this. In Oregon, the Secretary of State is working on this. Work in your state to make it easier for people to have early voting. Many of you come from progressive states that don't have early voting. New York, for example, makes it very hard for people who can't vote on election day to vote. If you're in a state that's still requiring that people have their absentee ballots notarized and the like, work to get those laws changed. And we should be thinking about, at some point, can we get new federal legislation that will protect the right to vote? And one of the things I think that we need here is the imagination of those of you who are likely to be here even after I lose my hair, just like Justin and Jerry. I think it's starting to thin a little. And I certainly have noticed a couple of gray hairs. You're not noticing them because I rip them out ruthlessly. It hurts, but, you know, what doesn't? So I want to encourage you to try and be imaginative, because the Voting Rights Act of 1965, when it was enacted, was one of the most imaginative statutes in American history. The pre-clearance regime was imaginative. It came out of the DOJ experience and the experience of Southern litigators. And they came up with a really imaginative solution. So we should be thinking about what's the next imaginative solution. And here, I think we should also be thinking beyond just the anti-discrimination paradigm that we've been using to this point, to think also about a positive or affirmative right to vote paradigm. That is, every other democracy in the world takes more responsibility for making sure that its citizens have the documents they need to vote and have the ability to vote than the United States does. And we need to make America voting great again. Thank you.
Thank you, Pam. All good stuff. So Pam alluded to the VRI. We have a votingrightsinstitute.org website that you can actually request information or look for opportunities to serve. We've tried to print out a voting rights resources. It has finally collected, I think, a lot of places where people can go to register to vote with all kinds of links, or where to report a voter intimidation problem, things like that. And I want to single out Harry Baumgarten, who's my colleague over here, who's really run and created this votingrightsinstitute.org website. Thank you, Harry, for tremendous, tremendous work. And it goes to something that Justin and Pam were talking about you can actually tell citizens that there's a click on the homepage that if you want to submit a complaint or if you want to just request information, you can actually just hit that button and send the information, and a lawyer will actually respond to it. One of the things we're looking for are people who are simply willing to handle just something that simple, so that when somebody writes and says, as somebody just did last week to me, I'm in the black community in this county in Georgia, and they've closed all the polling places in the black community, and now we have to vote at the police station. Is that illegal? Can they do that?
If you see something,
So immediately, the first thing that I always do is follow Justin's advice, which is I write a letter to the Justice Department and bring to their attention what's happening in every instance. And when I see Justin, he says always, "Thank you for sending that, and we are looking into it," or "We will take appropriate action." But it's worth it to just write to the Justice Department and get a record of that, because they, as Justin said, they are committed to ensuring the protection of the right to vote. We do have a couple of minutes for questions, very few, or if panelists have a comment that they've been dying to say since somebody spoke, we'll do that. But if somebody has a question, I will repeat it because this is being recorded. Yes, ma'am. Right. So the question is, for those who couldn't hear it, what do you do in, say, a city like Hattiesburg case where the factual findings by the district judge, you have to argue those on appeal? How do you attack those? Paul had alluded earlier to all the findings of fact in the Arizona case and how that was so helpful in the Supreme Court. What happens in a case like Hattiesburg when they go against you, Deborah?
Right, so in Hattiesburg, it's a little different because we think we had great facts and that the court misapplied the law. So we're arguing that it's legal error, that the court did not apply the appropriate legal standard to the facts that we think clearly show that there was a vote dilution case.
And it's interesting because in the photo ID case, when we went up to the Fifth Circuit, we had incredible findings of fact from the district court judge finding all the things I mentioned: poll tax, violation of the Voting Rights Act, intentional discrimination. And we argued, of course, that those findings were not clearly erroneous and were entitled to deference. And what that standard is so high, it essentially says that even if the Court of Appeals is convinced that the court below even didn't look at the facts correctly, they still have to defer to the lower court's findings. They can't substitute their own findings of fact for those of the district court. And yet the court figured out a way in the Court of Appeals to try to vacate some of the decisions based on legal error, claiming that it was legal error, for example, to find intentional discrimination because the district judge actually let legislators who opposed the photo ID law to testify. Well, how many legislators do you think testified for the state on the witness stand in the photo ID trial on behalf of the state of Texas? None. None of them would withstand cross-examination, and none of them were presented as trial witnesses. And so we introduced those trial depositions. And yet the district court was faulted for relying on testimony of people who said, by the way, the legislator who sponsored this told me when I asked him, why did you sponsor this? He said, well, I don't really believe in the law, and I don't think it's necessary because there's no voter fraud, but I drew the short straw. So that testimony was considered irrelevant to whether or not there was a state interest or intentional discrimination. So, sometimes the court makes it up as they go along in the Fifth Circuit. There's 10 bad people and 5 good people up there, thanks to Ted Cruz and John Cornyn. So, that'll change.
Let me just throw a comment in, Jerry. This is an example Jerry's telling you about the Texas voter ID case where intent actually was helpful because you can prove a constitutional violation by proving racial intent. The actually longstanding project by the conservative justices and others in the conservative movement has been to make all these cases turn on intent because they've made the bet that if you have to prove racial intent, most of the time you're going to lose. Oftentimes then they say, well, we didn't do it for racial reasons, we did it for political reasons or some other reason. And so, the Shelby County case can be viewed as part of that process. There's a lot of people who have long-term plans to go after Section 2 because it has a results test, not an intent test. We had a case last year in the court about the Fair Housing Act and whether it's okay to have a disparate impact test. So they think, in the end of the day, that their refuge is going to be to make everything be an intent test, or at least that has been. Maybe the world is not moving in that direction in our new Supreme Court, but that has been what's going on.
And let me say just one word about that, because we have a lot of litigation now that turns on exactly this question, and it can often be a false dichotomy. There is a recognition, there's a thought out there that if something's political, it's not racial, and that is flatly not true. Actually, then Judge Kaczynski, then Chief Judge Kaczynski, and now Judge Kaczynski, and the Ninth Circuit put it perhaps best, for those of you that haven't seen and are really interested in this distinction, a case called Garza versus the County of Los Angeles. And in this part of the opinion, he was both concurring in part and dissenting in part. It had to do with LA County, where I am now, and their redistricting plans, their long-standing redistricting plans. And he explained that racial intent does not necessarily mean animus. Once upon a time, there was plenty of that to go around, but it doesn't have to mean animus. The example he gives is, imagine you're a landlord. You don't feel one way or another about minorities living in your area, but your neighbors come to you and say, if you rent to minorities, property values are going to go down. So I don't hate anybody, but I'm not going to rent to minorities because I want my property values to stay exactly where they are. He said, is that racist? You better believe it. You intentionally took action differently with respect to minorities, and that is much of what we have seen lately in some of the cases that Paul was discussing before, where this fear of voting patterns or political change by minorities has caused action for underlying ultimate political reasons.
But using race. Taking action against minorities. The North Carolina case that many people on this dais have worked on now, currently pending in the Fourth Circuit. The allegation the United States has made is primarily that the actions that were taken were actions to engineer a better electorate for the legislature, an electorate they liked better, that would preserve their situation politically, but the actions they took were targeted to achieve that, for them, preferable electorate, directly at the ways that newly energized minorities had engaged in the political process in 2008 and 2012. And by acting against that constituency, they chose to act against people because of their race, perhaps for underlying political reasons, perhaps for other reasons, but it doesn't matter if those are the things that you're selecting. That is treating minorities differently. And I think there's a false dichotomy out there that just because something has political impact, it's therefore not racial. That is thankfully not the way the law has developed. Exactly.
And we see, and I think that's another reason, frankly, why we need a political gerrymandering doctrine, because when you file a case, oftentimes you're making racial claims because there hasn't been a political gerrymandering doctrine, so you would basically have to attack it as a racial gerrymander or a violation of the Voting Rights Act. And political parties use that because it's the only hook to really try to get out a remedy that'll benefit their party.
But I want to say one thing about this, which is, in the redistricting sphere, I understand why we need both doctrines. I think we already have the doctrine when it comes to these first-generation right-to-participate cases, which is the Supreme Court said in 1965, you cannot fence somebody out from the electorate based on how you think they're going to vote. And that was a case where Texas wouldn't allow service members who moved into Texas while they were in the military to vote in Texas because they didn't think they were real Texans. They were part of the Northern Army of Occupation. No, they didn't think they were real Texans, and they said those people can't vote. And the Supreme Court said you can't fence people out. And I think one iota of political motivation with regard to voter ID laws or voter registration laws or provisional ballot laws or the like is one iota too much under the Constitution. You know, obviously there's got to be some level of politics in redistricting, and so there it's a how much question, but I think it's an off-on question, or it ought to be, with regard to these first-generation issues. And that, you know, that's something that depends on having judges who are true to the constitutional values deciding these cases. And that's how elections have their biggest consequence, is the elections we have today determine the people who are going to be nominating and confirming judges tomorrow, which is going to determine the judges the day after that, who will decide the cases about voting rights the year after that, and the year after that, and the year after that, and for many, many years afterwards.
Yeah, they're absolutely right. I will say that in the Wisconsin case, we actually had, now this is a redistricting case, but we had the lead plaintiff testify, and we have a First Amendment claim in that case. And the lead plaintiff testified that he was penalized and harmed by using his past voter history, which reflects his political values, and people like him in his political party were assigned to districts based on their voting history and their political outlook. And that should be a violation of the First Amendment. I mean, he had the audacity to actually vote for candidates of his choice, and they used that voting history to then assign him to a district where his group, Democrats in this case, would have their vote minimized or canceled out. So I do think that, and I just want to give one more plug as the moderator. We're going to close out here because it's 2 hours. I just want to say that Armin Dörfner came up with a theory in Texas along the lines of what Justin was talking about earlier, where he came up with the theory of, look what Texas did with the photo ID. They picked and chose which IDs would be allowed. So they disallowed federal employee IDs. So an FBI agent's credentials are not good enough in Texas to vote. A Texas Ranger who protects the legislature's doors from when they are in session can't use his to vote. A municipal county employee can't use theirs. A state employee can't use theirs. And students at public universities can't use theirs. And every one of those that I just mentioned are disproportionately held by minorities vis-a-vis their position in the population. And so they rejected and picked and chose which IDs.
But look on the bright side, Jerry, your concealed carry permit is usable.
Right, and 91% of the people in Texas who have the concealed weapon permit are Anglo or white. And they picked and chose that one because they knew who it was going to enfranchise. So on that note, however, I will say there was a mountaintop that Dr. King talked about, and in his day, that mountaintop was very high. And so we have struggles today, but not like struggles that our people who came before us in this struggle were able to overcome. And we too shall overcome. Thank you again.
Yes.